Good afternoon, everybody. Hi, my name is Kim Koslow. I welcome our guests. So let me introduce our distinguished panel. Joe Considine. Joe has practiced law in South Florida since 1983. Joe has handled over 1,500 litigation cases in his career. Joe works with families whose loved ones have substance abuse and mental health problems. Joe has been invited this coming October to present to the Florida Association of Magistrates on the topic of rewiring the brain, the effects of substance abuse disorder. Next, where do I see my Michael? Is he in yet? No. Okay, I'm gonna back up. Well, I'll carry on. Michael Rabidou. Attorney Michael Rabidou has been practicing law in Florida for over 20 years. He received his undergraduate bachelor's degree in sociology at the University of Wisconsin and earned his Juris Doctor law degree at St. Thomas University School of Law in Miami, Florida. Next is Natalie Cohen. Natalie G. Cohen is an associate with the law firm of Hark Yan Marmer, located in Boca Raton, Florida. Her practice specializes in the areas of guardianship, incapacity litigation, probation litigation, estate litigation, mental health, and Marchman Act proceedings. Next is Mark Astor. Born and raised in the United Kingdom, Mark has been an attorney since 1994 before entering private practice. Mr. Astor was a prosecutor and has served the citizens of Palm Beach County as an assistant state attorney from 1994 to 1999. During his career as a prosecutor, he served as chief of 2 different county court divisions, was promoted to felony trial division. Next is Alan Levine. Alan Levine, Levine Esquire, is the founding partner of Levine and Associates and founding co-partner of Addiction Recovery Legal Services, LLC. As a Florida Marchman Act attorney, he personally represented thousands of individuals and families in 32 counties in Florida with regard to addiction and mental health issues. He has lectured and is an accepted expert and authority in the Florida Marchman Act. Next is Richard Casey. Richard Casey is the founding attorney of Richard Casey Law, a law firm dedicated to helping his clients protect their families. He has been admitted to practice law in Florida since 2018 in the United States District Court for the Southern District of Florida since 2019. And finally, our very own Jamie Clybourne. Jamie is a master's level clinician who brings 18 years of experience in the field of addiction treatment to Futures Recovery Healthcare. I will now be asking a series of pre-written questions to the panel. At the end of the panel session, I will be introducing my colleague, John Egan, who will facilitate an audience Q&A discussion. So let's start off with Mark Astor. First question. For those who are not familiar with the legal proceeding, what is the Marchman Act, Mark?
Well, good afternoon, everybody. And first of all, thank you to Futures for allowing me to share the panel with some really great lawyers, all of whom really know the Marchman Act like the back of their hands. So the Marchman Act is this wonderful statute that is specific to Florida. And it is a statute that allows for the involuntary commitment of somebody who has a primary substance use disorder. And so what that really means is that when, as a parent or a child or a sibling or a spouse, if you're sick and tired of being sick and tired, or if you're tired of seeing your loved one dealing with a drug addiction issue, which may or may not be accompanied by some type of mental health issue, if you've seen them go through multiple treatment centers, if you've seen them have relapses, if you've taken trips to the emergency room, and you want to do something about it, this is the tool that enables you to do it. So it basically would allow you to make a decision for your loved one that your loved one either can't make or won't make. It allows you to put them into treatment and to keep them there long enough so they can experience that miracle of recovery. So at any one time, you can keep somebody into treatment for a period of up to 90 days. The wonderful thing about the Marchman Act is that it's a two-step process. And the first step, which is the period of assessment, can be initiated on an emergency ex parte basis. So what does that mean? It basically means that they don't know it's happening until the police come banging on their door and pick them up and take them somewhere, where typically we're going to keep them for 5 to 7 days, get them assessed, get them stabilized, and get them detox, and have a clinician write us an expert opinion so that when we go into court, we can present that evidence to the judge along with testimony from the family and people with direct knowledge. And then we can ask the judge or the magistrate to send them to treatment for a period of up to 90 days. And that is the Marchman Act. That's what it is.
Thank you so much, Mark.
You're welcome.
Richard Casey next. Next up at bat, Richard Casey. If I were a family member or the clinician of the one needing help, how would I know exactly when to take action?
Thank you. Yes, and thank you for everyone for being here, and thank you for Futures for this opportunity. I think this is one of the most important questions, and families usually never know when to act, and sometimes clinicians don't either. And it depends, because everybody's family member is a little bit different, and it should be used when it's appropriate. The Marchman Act is a very good tool, and it's involuntary admission, so it should be used at the appropriate time. Now, the sad reality is that it's sometimes more appropriate than we'd like to imagine. Some of the key indicators of when the Marchman Act could be appropriate, if their loved one's in active addiction and regularly abusing substances, and they're refusing to admit treatment voluntarily. So denying pleas from the family, failing to take treatment recommendations from professionals or prior treatment facilities, a history of absconding, running away when confronted with treatment or eloping treatment, rejecting the services offered by an interventionist. Those are things that are going to highlight and show the court they're lacking that voluntariness and that willingness to go to treatment. And more importantly, those are the situations where that, when your loved one and you're in that struggle of finding out how to get them there. So there's further components to getting them to treatment. But when you start to see that they're suffering and that they're continuing to use and abuse substances, and you can't kind of negotiate with them any further, they're no longer willing to kind of follow the recommendations where they may have a professional or be unwilling to even see a professional. One of the simplest ways to put it down is this. If there's substantial proof that there's a drug abuse involved, if they've lost the power of self-control, so they're no longer really just having a glass of wine a night or recreationally using, but you're noticing that there's real life consequences, substantial changes in what their life should be looking like, and they refuse to stop taking substances. And then it's really a combination of the other two. Is the patient in denial? Are they in denial about this need for care and they're not willing to get treatment for themselves? They're refusing, they're running away, or they just won't even have the conversation with you. Or they're going to a therapist, but they continue to kick the can down the road. They continue to reject those offers for help, those pleas from their family. But also any other time that they may be, susceptible to inflict harm upon themselves or others, whether it's they've made threats or that they've actually taken some self-harm action against themselves. Those are times to really consider, how do we make this happen now, immediately, and so that they can't change their mind later on. So we don't want them to be able to, kind of coalesce for the time being and then put themselves back in harm's way a week later. But those are the times when families should start considering and professionals should start considering, is this an appropriate referral? When should I get an attorney involved? Denial, substance abuse as at such a high rate, and that combined with potential for self-harm is really an appropriate time to kind of bring us in as a team member and discuss the case further.
Thank you so much, Richard. Next, Natalie Cohen. Natalie, how can the Marchman Act be used to help those with primary mental health disorders and who don't struggle with alcohol or drugs?
Hi, good afternoon. Thank you for having us. And yes, this is a very good panel of professionals who fully understand the Marchman Act. To answer your question, I don't believe necessarily that the Marchman Act is appropriate for somebody with primary mental health disorders and who don't struggle with drugs or alcohol. Okay. it's very different than somebody who's struggling with co-occurring issues. And that happens a lot. It's actually probably a higher percentage of our cases than not. But when somebody does not have substance or alcohol abuse, I don't believe the Marchman Act is appropriate. Really deals solely with those issues. And then obviously also co-occurring. In that instance, I think perhaps if it's just solely mental health, a guardianship, if necessary, may be appropriate. And I know we all have heard about Britney Spears, right? And so, but that is something that in severe mental health cases can be approached on a very limited and streamlined basis. Obviously, not a clinician, and I believe lawyers, we stay in our lane, we obtain court orders, but also taking into account the family unit and perhaps what's in the best interest for everyone, including perhaps the person who's suffering with mental health disorders, right? And so a lot of the cases I've worked on have also case management, etc. But to answer your question, I don't necessarily think that the Marchman Act is appropriate in those instances. And that is not to say that there aren't other legal avenues to pursue, but Marchman Act may not be appropriate. Thank you.
Thanks so much, Natalie. And Michael Rabideau, what treatment options are available for a loved one once a Marchman Act is filed?
Good question. Thanks, Kim. Thanks, Futures, for having me. It's great to be on this panel. There's really a full spectrum of different treatment options, but you have to understand that usually when a Marchman Act is commenced, the individual is in a detox, right? And so once the person's in a detox, an assessment is going to be done, and that assessment is going to have a huge impact on the type of treatment that's going to be recommended and, eventually ordered, hopefully, by a judge. So the assessment may call for, it's usually some sort of residential care, so inpatient, perhaps with a step down, followed by PHP, which is partial hospitalization, and then followed by intensive outpatient or outpatient. It's pretty rare that you would see an assessment that is recommending only outpatient care, right? Because if that was the case, this really wouldn't be a Marchman Act. The person probably wouldn't be that far along the way in his recovery or his addiction that it would require only outpatient. But one of the problems that I've seen is when there is no insurance, or the insurance will only cover up to a certain point, because then the options for treatment become very limited. There was a Marchman Act case that I had during the height of the pandemic, and the respondent did not have any insurance. So, thank goodness we have Drug Abuse Foundation, which is a government subsidized treatment facility. But due to the pandemic, they had decreased the number of beds by 50%. And, as the other attorneys can attest to, it's usually it's hard to get somebody into Drug Abuse Foundation anyway because of the waiting list. So what happened in this case was we basically had to decide on a different level of care at a different facility, because there was the waiting list was just way too long, and the person just kept going downhill. And after a month of that, the family had to step up and do something, and I think he ended up going to the Fern House, something like that, which obviously really isn't inpatient, wasn't what the assessment called for, but it was an option. It was an option that the family had to act on. So in essence, there's a full spectrum of treatment. A lot of times it's limited by the type of insurance the person has, or if they have insurance at all.
Thanks so much, Michael. I love that sound effect. It was kind of appropriate, right? The police siren. Anyway, moving right along. Joe Considine, what happens if they violate the Marchman Act order?
So thanks to Futures. And this is so important that you guys are doing this and having these brilliant colleagues of mine on here as well. I had a client back in January who had hired me to get a Marchman Act on his wife. And he had said to me, if I had known about the Marchman Act my son who had overdosed weeks earlier would still be alive. So this is critical what you guys are doing here. And and I kind of take that personally as lawyers, and also in treatment, and people in the mental health practitioners. It's up to us to educate the public about this very effective tool. So what happens, and this kind of answers the question about why it's effective. What happens when a person violates a court order, whether by absconding from treatment or not following treatment protocols, is that the court can hold that person in contempt of court. This is a civil case. It's not a criminal case. And the way that we enforce court orders, civil court orders, is to find somebody in contempt, and the court can actually incarcerate the person until that person decides to go back to treatment. And I'll tell you, and I assure parents this, in the 500, 600, 700 cases, Marchman Act cases that I've handled, 3 times we've had to incarcerate somebody for less than a week in each case, and they've all come back into treatment. And when I first got into this, I came up through recovery in the Al-Anon program, and heard that people, good-meaning, well-intentioned people, talk about that. People don't get sober until they really want to, and kind of step over the bodies. Except for that, we lost 70, 80,000 people a year, more people than in the entire Vietnam War because of opioid, and a like number because of alcohol related. And we can't wait anymore. And not only that, but the science shows us, and I've researched, I've got the studies, I'll be happy to send you the citations. The science tells us that involuntary commitment to treatment is at least as effective, if not more effective, than voluntary treatment. And the reason for that, I believe, is something called the nudge from the judge. If you've got a court order that says that you've got to stay in treatment, and if you violate that, you could be held in contempt of court and you could be incarcerated. That creates skin in the game. We as human beings don't do much, it seems like, until there's skin in the game. And those people with substance use disorders even more so. That creates the leverage for the individual to really think long and hard about whether they want to subject themselves to the legal process. And in closing, I just want to talk about the program that has the most success in dealing with substance use is the Commercial Airline Pilots Association. In conjunction with the FAA, they've created a program that lasts 2 years, and they have an incredible rate of success, 80%. And why is that? There's 2 things. There's leverage. If you want to get back into the cockpit, you're going to do this program. You're going to go to treatment. You're going to do all the things that they want you to do for 2 years, and you're going to pee clean all the time. That's the leverage. Well, the Marchman Act, the analogy to the Marchman Act is that we give somebody this leverage that if you want to stay out of jail, if you want to avoid being held in contempt of court, you're going to do these things. The second thing, the reason that it works, is it's long-term. And I'll talk about this in a minute when I answer the other question. We're able to keep people, and I know a number of people, my colleagues have done this. I've had people under the Marchman Act for a year and a half. So that gives the brain the time that it takes to heal. Thanks.
Thank you, Joe. Thanks so much. Next is Alan Levine. Alan, does a Marchman Act stay on the record forever? Or will this be similar to having a felony on a record?
Well, first of all, thanks for doing this. I think it's great that we're educating the public and everybody we can with regard to the Marchman Act. There's about 10,000 Marchman Acts filed in the state of Florida every year. And every one of those people are going to be needing providers, for their loved one. And it's important that the providers are fully aware of how this works. So specifically to answer your question, the beauty of the Marchman Act, it is deemed confidential. It is a civil proceeding, as you already heard. It has absolutely nothing to do with the criminal aspect of the courthouse, meaning that it's nothing like a felony or a crime. It's a civil proceeding, and because of that, it has the ability for us to handle it a certain way pursuant to different rules than we would see on the criminal side. With regard to the confidentiality, the statute allows for rights of the respondents, who are the individuals that we're trying to get into treatment to get help. And 397, 5017
as well as 397, 6760, all deal with the confidentiality aspect of this. In July of 2017 is when they actually changed the statute, and they actually put confidentiality language into the statute, making all of this confidential. Beforehand, we literally had to go ahead and file specific pleadings to pull it out of the public record. I don't know how many times I had to file in Palm Beach County to convince them that it shouldn't even be on their website. And we had to do that. But eventually the statute did change. With regard to the confidentiality, basically everything we do is going to remain confidential. It will not be a matter of public record. It will not show up at the clerk's website. When we do get down to the situation, or the unfortunate situation, where somebody may be held in contempt of court and they have to get picked up, there would be a writ of bodily attachment, and they would have to get picked up by law enforcement and brought back in pursuant to that contempt order. That unfortunately will show up when they are arrested, and it'll show up as a contempt of court, but it won't say specifically that it was a Marchman Act. So it is deemed confidential. They did change part of the statute where the petitioners and certain treatment providers can get some of this information if the clerk is willing to give it to them. Instead of using the word shall, they use the word may. Another part of the statute that needs to change. But generally speaking, the only other aspect is when you get Marchman Acted, information by statute is supposed to go to Florida Department of Law Enforcement, where they are supposed to suspend a concealed weapons permit if you have it. Some counties do follow through with that. And this is the same thing for Baker Acts, by the way. Some counties do follow through with it and some don't. And if a person has their concealed weapons permit suspended, they do have the ability at the end of the Marchman Act to go in front of a circuit judge and try to petition to get that license back. So other than that type of communication, generally speaking, it's completely confidential, and there won't be a record. And I love it when respondents always say, oh, you're ruining my life. You're giving me a record. Everybody's going to know about it. No, they won't. And that's your answer.
Thanks so much, Alan. Thank you. And Jamie Clyburn, what is the treatment center role in the Marchman Act?
Hi, thanks, Kim. Our primary role as a treatment facility is to engage the patient in treatment, assess them, and then make clinical recommendations and provide those recommendations to the court. We also reach out to family members for additional information. And, you know, a lot of times they're angry with family. So we revisit it each week if they're declining to sign a release for us to speak with family. We continue to talk about the importance of that, for getting the full picture, and also to help them come to terms with that anger and resentment that they may have. We also help them process the consequences of their addiction. So that might be, you know, additional legal matters, DUIs, health concerns. It could be, you know, usually there are many relationship issues that we need to address. But it's always important for us to point out to them that the family was concerned enough for them that they did take this legal action, and we walk them through step by step. We, the clinician who completes the Marchman Act assessment will accompany them to court, all of the court hearings, and may even need to testify as to what the recommendations were. But aside from that, you know, they're treated just as any other patient is. They, you know, participate in the full clinical program. They have their individual and group sessions, and you know, they tend to do pretty well. You know, over time, they really do start to, for the most part, they start to gain that acceptance of being in treatment.
Thanks so much, Jamie. Mark Astor, what is the main difference between the Baker Act and the Marchman Act?
Myself. So the Baker Act, like the Marchman Act, is an involuntary commitment statute here in Florida, but there's a real difference here. So the Marchman Act is a general, at least for our discussion, is a statute that's designed to get somebody into treatment. Okay, it's not designed to it's not designed to be used like the Baker Act, which is designed to be used for emergency stabilization only. So there is, within the Marchman Act, and I'm going to try not to confuse you, there is what's known as a 72-hour emergency hold provision, which is what's contained in the Baker Act. So typically the Baker Act is initiated one of two ways. Either law enforcement gets called to the scene of an issue, or somebody gets taken to the emergency room, and typically an emergency room doctor will issue what's known as a professional certificate, and they will involuntarily commit the person for a period of up to 72 hours when we're talking about an adult. The idea is that within 72 hours, they're supposed to be stabilized, and at that point, they're supposed to be released if they no longer present as a danger to themselves or somebody else as a result of some type of mental health issue. If the facility where the person is now being held decides they want to hold them beyond 72 hours, they're supposed to, and I use that word supposed to, file with the court what's known as a petition for involuntary placement. And at that point, the person is entitled to come before a judge. They have a right to counsel. And then the court makes a determination if they should continue to be held beyond the 72-hour period. Now, within the Marchman Act, we also have that 72-hour period. However, in Florida, at least here in South Florida, we're not really using it for that. So if you want the sort of the real distinction in the real world, as we use it down here, is the Marchman Act is a treatment statute, and the Baker Act is a statute for emergency stabilization only. It's not designed for treatment. Now, with that said, we get calls pretty much on a daily basis from people who call up and they say, I want to Baker up my loved one. And I say, why do you want to do that? And they say, well, they need to go to treatment. And they say, well, I'm down here at the courthouse right now. I'm filling out the paperwork. And I say to them, if you're looking to get them into treatment, unless you're dealing with an emergency, don't Baker Act them. Because if you Baker Act somebody to a facility and the facility decides after 72 hours they want to keep them, guess what? They're going to run to court. There's going to be a hearing, and your loved one is going to be committed potentially up to 6 months to a state mental institution. And so when someone is Baker Acted, what is happening is the state is taking care, custody, and control of them. In other words, they become a ward of the state potentially. And so this poor family that wants to get treatment for their loved one ends up having them become a ward of the state. And I'll give you an example. I had a guy that called me, 75 years of age, okay, was a veteran, worked for the federal government for many, many years, and his wife was having issues. In fact, he'd even called the police to the house, and an officer said to him, you should go file a Baker Act. So he did. He ran down to the courthouse. He filed a Baker Act petition. The police came back to the house. They took her. And then 72 hours later, he couldn't get his wife out of the facility. And he called me, 75 years old, hysterical, crying. Okay. I had to go back into court. I had to file what's known as a petition for habeas corpus and get a judge to order her released. And so the confusion is when people treat the Baker Act as a treatment statute, which it is not. And so I hope I haven't confused everybody, but that's the main difference: stabilization versus treatment.
Thank you, Mark. Richard Casey, what exactly is guardianship, and how does this affect the ability to help a loved one?
Thank you, Kim.
Yeah.
So I know we've spent a lot of time speaking specifically about substance use disorders, but as mental health practitioners and professionals around the state, there's going to be times where you run into cases where, substances may be involved, but a Marchman Act may not be appropriate. Maybe there are no substances are involved, and it's really just someone with solely mental health issues. And that deterioration is really occurring to the point where you want to be able to help them making the decisions about their medical care for them. You want to be helping them make decisions about their finances, place to live. And they may not be able to take care of those things themselves. So guardianship is a legal proceeding where really where one person is no longer able to take care of themselves, make sound decisions for himself or their property, and they appoint a guardian or a surrogate decision maker, someone to take the place of those decisions in their life, who can handle all of those types of things for someone with mental or physical disabilities. And so in the mental health space, it's very possible that someone has mental health disabilities. Now, one of the easier ways to get that to happen immediately in a similar fashion to the Marchman Act is through the emergency temporary guardianship. Now, it does require an evaluation and assessment being done in advance and having a doctor or a professional do that assessment. So ultimately, they can have that proof in court that they are of such a limited capacity and do actually need to have a guardianship put into place. So that point of the emergency temporary allows it to step in immediately and to help making mental health treatment decisions by a trusted advisor, right? A trusted surrogate, whether it be a family member or a professional in the space. Most people choose to have a family member step in these cases. But really it allows to avoid kind of self-neglect, allows to avoid those types of things of medication non-compliance, unwillingness in certain areas to admit to treatment facilities. Additional orders can be given by the court to require treatment from the ward or the incapacitated person in the case of a guardianship, although those are not necessarily a guaranteed component of the guardianship. What it does allow, though, is that placement for treatment, decisions on medical care, decisions on whether or not medications are appropriately prescribed instead of refused by the patients, as well as housing, residential, and support services can ultimately be made by someone who is of competent mind versus by someone who may be struggling with a physical or mental disability, as well as the handling of their finances. And so professionals and families that are wondering how to help someone that may not have a substance abuse disorder, but may have a simple mental health disorder, can look into how they can step in under the guardianship. There is such thing as limited and plenary guardianship, which are more longer term guardianship statutes. Getting those absent the doctor's recommendation upfront, absent that assessment, may be slightly harder. And some of our traditional mental health concerned patients that kind of mimic the substance abuse track versus the older adult dementia or Alzheimer based guardianship clients. So it is important that potentially we work with other professionals who can help navigate that person to an initial assessment, get a doctor's evaluation, and then proceed from the guardianship post-evaluation versus trying to use the guardianship statute to ultimately use the court's initiated evaluation. So the best likelihood of helping someone with mental health disabilities is usually when we have some level of compliance in the process of getting them evaluated on the front end and determining if this is an appropriate solution for you and your families.
Thanks so much, Richard. Natalie, what if there is a power of attorney or healthcare proxy for the loved one? How does this affect the ability to help?
Thank you. Hi. Yes. So in regards to the Marchman Act, and this is kind of what this discussion's about. When the power of attorney or healthcare surrogate comes into play is really when a loved one or the person who's given be a family member or a trusted person those rights. You're not really giving those rights away or delegating those rights like a guardianship. Those only come into play when the person is incapable, essentially, honestly, of communicating their wishes, or fully incapacitated. So when they come into play, unfortunately, in my experience, has been when somebody's been hospitalized on a ventilator, has overdose, and there's significant brain damage, and we have to step in and make health surrogate decisions on so it's not a best case scenario. In regards to, and one thing to note is the power of attorney can be revoked at any time by the person who, so in the case of a Marchman Act, by the respondent or the person who suffers from a substance use disorder. So I don't necessarily think it's appropriate unless there is a very significant or severe issue. And if you want to delegate rights, as opposed to just essentially transfer them when you're incapacitated and not able to communicate, you once again look more for a guardianship proceeding, whether it be an emergency temporary guardianship, which is an order that expires within 90 days, similar to a Marchman Act, or whether it be on a limited or plenary basis, like Richard said. So those are the only times in my experience they have come into play, because we don't want to leave it in facilities' hands to have to look at family members, trying to push treatment, and then of course you have the person who's suffering from the substance use disorder. What's nice about the Marchman Act is it takes almost the decision making out of both parties' hands and puts it in a judge's hands. So now you have a judge order. So that's my opinion. Thank you.
Thank you so much, Natalie. Michael, what if the loved one is not from Florida? How can we utilize the Marchman Act if the family is out of state? Really important question.
Yes, we've seen that a lot. You know, the short answer, Kim, is get them here. That's simple. You know, I mean, we have to remember that the Marchman Act is a Florida specific law, right? It's not a federal law. It's not a national act. This is the Marchman Act is a Florida act. So what that means that a judge sitting in Florida cannot force somebody who's residing in California to go to treatment. But the judge can mandate that same individual if that individual is within the state of Florida. And the beauty of the Marchman Act is that it doesn't require a specific period of time for the person to be residing in the state of Florida. So, you know, we've had instances where, you know, the family was in California, you know, and so was the person that was abusing substances. And, you know, we would advise the family, try to talk your son into coming to Florida, right? And for me, namely Palm Beach County, try to get him into Palm Beach County just simply for a detox. And as soon as he would come for the detox, then we can begin the Marchman Act. And as long as you do it quickly enough, you can kind of lock the person in until we get in front of a judge. You know, we can file the ex parte petition and follow that up immediately with the petition for services. So the person does not have to be in the state of Florida in order for the process to begin. And the process I'm talking about is setting things up with the family. But once we're going to serve the individual and begin the treatment, the person has to be in Florida.
Thanks, Michael. Joe Considine, does the court order affect where the loved one can find treatment or length of stay?
Absolutely. But, you know, I'm not going to leave it at that. The answer is yes, of course it does. That's the document. The order is the thing that the treatment center, the family, everybody involved in this process is going to look to see, you know, what is the court requiring here? And so, yes, it's going to be the treatment facility and the length of stay. It doesn't say anything about levels of care of services. That's left to the good people at Futures and other good treatment centers. I also want to just give a shout out to Jamie Clyburn. Jamie does such a good job in court, and I just want to congratulate her on that whenever I have her as a witness. So we look to the treatment order, and as I think Alan mentioned, or someone mentioned before, that the order by statute can be for a period of time not to exceed 90 days initially. That can be renewed any number of times as long as the treatment provider continues to believe that the person needs some level of services. It's not just residential. It can be, the person can step down from residential to PHP to IOP with sober living and so forth. And like I've said before, I've had treatment orders renewed 4 and 5 times if the person is in treatment at some level of care for a year, up to a year and a half. Now, why is this important? So the families come in and they feel ashamed. They feel, you know, mom and dad, like, where did we go wrong? I mean, there's nothing that we can do that, you know, can get this. No amount of begging, borrowing, stealing, cajoling can help our loved one. And so, you know, what they need to know about is that prolonged exposure to substances rewires the brain. And the good news and that's called neuroplasticity. The good news about neuroplasticity is it works both ways. Not only does the person with chronic substance use disorder rewire their brain so that their brain is hijacked, but once they get into treatment under this order, you all have a chance, and it's our job to set it up for you. You all have a chance using neuroplasticity to help rewire the brain towards recovery. And Kim, thanks for mentioning that part of our job too is to educate the judiciary and the magistrates and the hearing officers. And I'm blessed to have been asked to speak to them about this idea of how substance use disorders rewire the brain so that they get a better idea that they're dealing with something that's not so voluntary. And it really helps the parents to know this, that your loved one, you know, is not intentionally going out and doing all of these things. They're doing these things because their brain has been hijacked. And it helps them realize that the neuroscience is important. So it takes a little, it makes it easier for them to make the decision about saving their loved one's life. So the treatment order is vital. It's also vital because if we want to help the person held in contempt, the order needs to be very clear so that the person's aware of what's expected of them. And so we make sure that the orders are written in such a way that they're very clear so that the individual knows what's expected. Thank you.
Thanks so much, Joe. Alan Levine, how does age come into play for the Marchman Act? Are there restrictions due to minors versus being an adult?
Now, it's an interesting aspect when you actually look at the statute in its totality. When you're dealing with non-court involved admissions, they actually have a specific section of the statute which allows for voluntary admission for minors. In fact, the age of disability, meaning that a minor typically is considered 18 and less, but under the Marchman Act, they take that away for minors that are voluntarily going into treatment. So they would get the same protections as adults and they can make that decision. However, we're talking about, Section 5, we're talking about involuntary Marchman Acts, and specifically in one section that talks about who can petition, minors are included, but it has to be done through the parent or the legal guardian who can petition the minor. Now, as to how it's handled, I mean, look, I've done this to doctors, lawyers, I've done this to sitting judges, 14-year-olds up to 76-year-olds. And yes, minors are handled differently because of the treatment aspect and how that has to be handled. When it comes to the litigation aspect and you're litigating the Marchman Act around the state, a minor is going to be handled the same way on the involuntary commitment section of it. You're going to go through the same procedures. Now, the only issue is once they're court ordered, where are they going to go? There's only a few places. In fact, there's even fewer places that are actually designated addiction receiving facilities pursuant to DCF that are locked receiving facilities for stabilization. We've got around 24 around the state, and out of that, there's only a few that will take minors. So when you're dealing with a minor case, you're dealing with a lot of different strategies you've got to employ to take control of the child, where they're going to go for treatment in the long run. And it becomes a problem in Florida because we just don't have a lot of treatment options for them. But generally speaking, they're handled the same exact way. It's just that the strategy and the treatment and where they're going to go becomes more difficult. And also that consequence that's put in play in the Marchman Act, the consequence of being held in civil contempt of court. Technically speaking, when a person is held in contempt of court, they could go to jail, whether it be a day, a week, a month, or up to 6 months. But the way they get out of treatment and the way they avoid it is to simply be compliant. I mean, the way they get out of jail is to simply be compliant with treatment. With a minor, it's a little different because the court has limited power with regard to taking that minor and incarcerating them. Technically speaking, they're not allowed to do that through contempt. They're not allowed to punish them or try to compel them and putting them in a juvenile detention center. Some jurisdictions, the judge will do it. Some recognize they can't. So it becomes a problem there as well. But generally speaking, from a litigation standpoint, they're treated the same as an adult.
Thanks so much, Alan. And the final question of our formal pre-written questions is to Jamie Clyburn. And it's, how does the assessment come into play for a loved one in court? Jamie.
So the assessment process really begins within the first 24 hours. They're seen for their physical exam and they submit a urine drug screen. So that's really helpful information for us when it's time for us to do the assessment. We also review all collateral information. So a lot of times there are sworn statements from the family members that come along with the order for assessment. So we review all of that thoroughly. And then we will, in addition, reach out to family members if, like I said before, if there is a release in place, just to review everything and find out if there's any more information that maybe they didn't put in there. So then a full psychiatric evaluation within 72 hours, and then the Marchman Act assessment itself, which is very similar to a biopsychosocial assessment, and that needs to be completed by a qualified professional. And we as a facility have found it very helpful to have someone other than the primary therapist to do that assessment. That helps keep rapport intact with the primary therapist. And, you know, they can really work on the issues aside from, you know, talking about the assessment and the recommendations. So once the assessment is completed, we send that to the court along with our recommendations for treatment. So that would be specific as to level of care and for how long. And then, you know, those would also go out to, you know, anyone else that we have a release for. Our clinical recommendations are always based on ASAM criteria because it's objective. And for those of you who are not familiar with ASAM criteria, it's the most widely used guideline for placement, treatment placement, transfer, and discharge for anyone with addiction and co-occurring disorders. So there's 6 dimensions to ASAM. The first is detox and withdrawal potential. If there is a high withdrawal potential, they would obviously need detox as the first part of their treatment. Second is the biomedical conditions, could be liver disease or other issues related to their addiction. There's also the emotional, behavioral, and cognitive component. So we talked about co-occurring disorders, so that would fall under that. Readiness to change is another dimension, and that is where we look at their attitude towards treatment and also their motivation. You know, are they motivated? Are they only here because of the Marchman Act, or do they have some internal motivation? And then relapse or continued use potential. Do they have a history of chronic relapse? Do they have any long periods of sustained sobriety? So that all factors into our recommendations. And then finally, recovery environment. Do they live alone? Are they prone to isolate? Do they live with anyone else who maybe is actively using? So that kind of ties in with the relapse risk potential. And then there are times when we submit the recommendations and then it may change. So new information may come to light, or the patient may, you know, we may see a regression during treatment. And so then sometimes we have to make adjustments to that. And then we would also notify the court if the patient leaves prematurely against medical advice, against staff advice. So like I said before, we attend the court hearings and sometimes are called to testify. And, you know, it's up to the judge whether or not they are going to order the patient to follow our recommendations.
Thank you so much, Jamie.
You're
And thank
welcome.
you for everybody for the pre-written questions and answers. More importantly, your answers. At this point, I'd like to turn it over to my colleague, John Egan, and he's going to facilitate an open Q&A. Thank you very much.
Good afternoon, everyone. Thank you, our panel. I hope everyone found value in the expert panel discussion today. We're going to open up to the audience to ask the panel questions pertaining to the Marchman Act. Please keep your questions on topic. And also, just so you know, we will be distributing the contact information of all of our panel members after the event if you have questions beyond today's discussion. But our first question is going to be from Calais.
Hi, my name is Callie.
Callie, sorry.
Hi, I work in the substance use industry with Aware Recovery Care. So I first wanted to kind of let everybody know that I am a Marchman Act success story. My parents retained the services of Mr. Levine about 4.5 years ago. I was very angry at him, of course, kind of by proxy, but so today I have 4.5 years clean and I'm doing pretty well, I'd have to say. So I did have a question though. So obviously the substance use industry is a business and, you know, people don't go to treatment for free. So there's that aspect, but what about financial assistance with legal fees? What if somebody can't afford to retain an attorney? Then what happens? Because I know that's a question I get from families a lot. And also, you know, how do the insurance companies play a part? in this mandate, because you can't, sometimes insurance companies won't pay for more than 30 days. So I just didn't know how that factored in.
Alan, I believe you've been chosen.
I'm really, really happy to see we were able to help you and that you're doing so well and that you're now helping other people. And that's one of the things that at least, we always strive for here in my practice. We want to see these people get involved, that get better and help other people. When it comes to people that can't afford an attorney under the Marchman Act, they go into court and they can handle it, as we say, pro se. And I've worked so hard over the years to try to amend the statute to allow those people to be successful as if they had an attorney when they're litigating this Marchman Act. Originally, it was designed so individuals can handle it on their own. However, there's a lot of pitfalls for them along the way. And with simple statutory changes, it could help them. But our legislature, I've had something in front of them every year for the past, 14 years. We don't get anything passed. They're really not interested in doing it. However, listen, in my practice, we reduce our fees because we want to try to help everybody based on financial need. We provide, payment plans. We do whatever we can, to try to help them out. Individuals that call us and they simply can't hire an attorney, we give them the advice as to how to try to walk through it, what pitfalls to look for, because, every county handles it differently. And that's an important aspect. When it comes down to the insurance component of this, it's very interesting. I find a lot of providers deal with insurance carriers a different way as to how they're going to get paid. Some carriers do not want to pay when they find out they're being court ordered into treatment. And it's really important that the provider, recognize when they're dealing with an insurance carrier as to what they're going to tell them. I mean, the reality is, understand what this court order does. This court order orders an individual to do something. It orders them to be compliant with treatment recommendations. It doesn't order them to walk into your facility through that front door. That's actually something they're doing on their own. It's an important aspect for an insurance provider to be aware of if they refuse to pay because they think it's an involuntary commitment order. But those are internal business decisions between a provider and a carrier, and they're all vastly different. And I know it's a difficult thing to deal with, and it's something that should be changed in the future, but all we can do is deal with what we have.
Next up, thank you, Alan. Next up, we'll have John Poles. If you have a question.
Thanks, everyone. Yeah, I've had the pleasure with working several of the attorneys on here, I think 4 out of 6. I had a question. So I facilitate a lot of interventions, and I like to do a Marchman Act in conjunction with that often. Sometimes the respondents they'll receive the paperwork and they'll read for the emergency assessment and stabilization that there's that 5-day period, right? And so sometimes they surmise that after the 5 days, if they don't go to court and the court order is not in before that they can leave, right? So there's kind of almost, lack of a better term, a limbo period. What can be done to keep the person in detox, in treatment, if it's not, if the court order is not in before then?
I'll be happy to answer that.
Joe, is Mark, either one?
I'll answer that. So, John, good question. And there's a provision in the Marchman Act that says that if before the 5-day period is up, the petitioner files the petition for involuntary services, the facility can continue to hold the individual by law. Never tested that, so that the facility should know that. And in the information I always provide to the facility, I tell them, I point out to that statute, I send a copy of that statute and say, as long as the petition for services has been filed before the 5-day period is up, which is another reason why we need to get the assessment in ASAP, so that we can file the petition for services. Once that happens, then the facility can legally continue to hold the person until there's a hearing on the petition for services. Thanks.
Johnny, can I just add to that?
Sure.
No, I agree with what Joe has just said. And I think Alan made a really good point where he said, every county handles this differently. And he's 100% right. And there are some counties that are really switched onto this stuff and some that are not. Now, when it comes to this, extending this 5-day period out, there are some counties where as soon as the petition for treatment services is filed, and they know they can hold the person pending further order to the court, they'll do it. There are other counties that even though you file the petition and you say, listen, there's a provision in the Marchman Act which says you can hold them, their provision is, position is, well, they've been detoxed, we're done, goodbye. And that causes a real problem because it, number one, leaves a period of time where the person can relapse, but also really, creates a period of time where they might actually just abscond from the jurisdiction of the court. They end up in another county, you potentially have to refile the case. They leave the state, as Michael pointed out, you're really, SOL, because now you're outside of the jurisdiction of the court, of any of the courts here. And so, the goal is to try and sort of go from pick up for the assessment period, file the petition for treatment services, have the hearing, and off to treatment. So you don't have any gaps. Some counties will work with you on that and some won't. And that's just sort of the nature of the beast here in Florida. So I just wanted to add that bit in.
Thanks, Mark. I believe we have time for maybe one more. Michelle Siegler, do you have a question?
Yes, I do. Thank you so much to the panel. This has been very helpful. I also work in the field and help individuals. My main question would be, I know Michael touched on it a little bit, when somebody doesn't have insurance. So in that case, are we just going to have to look at, what's in the local area that helps people, like a behavioral health hospital or something like that? And then the second question is, what type of an attorney would you hire? Would it be a family law? Like what type of attorney would you be looking for? And the going rate, if you could give me a range of what that would cost.
Richard, do you want to field that?
Yeah, no problem. I appreciate it. So I think that your first question, you have this insurance and payment process, and it really is important to work with the facilities in advance to determine the actual payment. Now, you mentioned a cost, and the second part of your question, if you wouldn't mind repeating it for me so I can just get a clarification.
Sure. What I was looking for is what type of attorney would you hire? So there's like family law, criminal, of course it wouldn't be, but what person would you try to look for? Like I'm much more north than West Palm. I'm in the Vero Beach area. So I would wonder what's in my area and what's kind of a rate, $3,000 to $5,000. Like what are we looking at for a cost if I was working with a family?
Really, any of these 6 attorneys, and including myself, really work around the state of Florida. And there may not be someone in your geographic location which actually practices in exclusively this area, or has a large portion of your practice in this area. So there may be other professionals that may or may not know much about the substance abuse field, even if they practice in a particular other area of law. This group of professionals here actually included, we've specialized in this and work all across the state. Now, that means that families that may not be in your geographic area may not be able to have an in-face consultation. The benefits of phone calls and Zoom accessibility now allows them to get a personal feeling for the attorney that's who they're working with. So, for instance, myself, I work with families from out of state all the time, so they don't have the ability to come and see me at my office. I'm also willing to go and visit providers and facilities and professionals around the state to build a better in-person relationship or host Zoom calls as well. So you can, rely on someone who's actually got the expertise in the Marchman Act space, even if they're not geographically located as close to you in your facility. And by building a relationship with one or multiple of us over time, you'll ultimately have a feel for how they'll practice, how they'll treat your families, what their bedside manner is, and ultimately what their knowledge of the actual treatment that takes place inside of each facility. So they can get that kind of understanding of how you operate, how the county there operates, how the attorney and the families will work together to provide you the most coalesced care that you ultimately need. And I think that this panel is a great place to start for who you'd hire.
Yes, definitely. And what would the rate be, if you weren't giving a discount and stuff like that, if you were just your rate for this?
I mean, everybody kind of charges probably a different rate. I mean, I know the range is probably somewhere around the $8,000 to $12,000 range, and some of them do a flat fee structure, and some of them do a pay as you, an hourly or a minimum retainer, and then hourly beyond a certain amount of hours. And so it really depends, depending on the services that would be required, if there's travel involved, and every single attorney here probably does work with families on rates. I mean, maybe there are some that don't, but I certainly will work with the family on a rate when we're determining what it is that they can potentially afford. But I would say it's somewhere in those high aughts to low teens in that general price range.
Okay, perfect. And just circling back to that first question about if they don't have insurance, would the best thing to do when you're starting to work with an attorney would also be decide and figure out where your loved one is going to go, can afford to go, and sort of have that in place as you're working with the attorney?
Yeah, absolutely. Part of the biggest thing, and depending on if families especially are calling directly, and they may not be working with a professional, or they are working with a professional, but they're still at the beginning of the investigation phase of which treatment provider is appropriate for my loved one and how will their needs be met. Part of the attorney's discovery process is actually uncovering a lot of information that the family wouldn't necessarily have spent the time putting down on paper. But it's important to assess kind of the quality of care or the specialization of the treatment provider. And so a good Marchman Act attorney will ultimately be using potentially external resources of other intervention, case management, or services similarly if they have the resources to. And if they don't, they'll use their own knowledge and expertise that they can to get them in touch with the clinicians at potentially multiple facilities so that they can determine insurance benefits, determine the appropriateness of the treatment provider, determine really, is this a specialized need case that needs to be referred to a specialized need facility where there may be an underlying extreme amount of trauma, or there may be such a severe co-occurring mental health disorder that's going on, or just the environment themselves needs to be of such a nature that they can truly handle that person's needs. And so a good attorney will work with, free resources in the community to benefit the client, or to potentially activate, some other support services that they could afford to have for a clinician to do more of those evaluations with the attorney as they progress forward. So for the insurance
Fantastic. Yeah, that's good.
Thank you.
Thank you, Richard.
And I want to thank everyone for joining us today. Thank you for the panel that came here. We at Futures, we're very honored to have everyone here. If anyone has any other further questions, I'm sorry we ran out of time, you can email them to marketing@futuresrecoveryhealthcare.com, or contact your local professional, whether it be any employee here at Futures. We would love to connect you. And as I said earlier, we're going to email everyone the contact information of our panelists if you have any questions, further concerns. But we are so happy that you came, and we hope that you left here learning something and why Florida still remains the #1 place for loved ones to get well. Thank you so much for having us. Thank you.
Thanks, John.